So, how long do I, as an injured worker, have to file a claim? That's what we're answering today. My name is Kaplan Morrell, and I'm with Kaplan Morrell. We're attorneys who help people with injured workers' injuries on the job here in Colorado. And this is our second video on the issue of time and why things take time in workers' compensation claims, why things take time in legal claims, etc. And last time we did about how long do you have to report your injury, because oftentimes you see signs that say you have to report your injury in writing in 4 days, and then your employer of course says, well, sorry, you didn't do it, so you are SOL, which is not true. Look at the video on that. But today we're going to be talking about how long do you have to make a claim for compensation. And one of the things that hopefully you understand is that in lawyer land, words that you think are the same, but they're not, mean completely different things. So reporting an injury is not the same thing as making a claim. There are two different things. Reporting an injury is just giving notice, just telling your boss, hey, I've been injured. Reporting your claim may even be, doing emails to the insurance company, or even talking with the insurance company, even giving a written or recorded statement to the insurance company. That's notice, giving notice of a claim or notice of an injury. But a claim for a work injury is called a workers' compensation claim, and it is a specific document. It's so interesting. I have to, It looks like this. It's a document. It's created by the state of Colorado. It is a specific form, and you send it off not just to the insurance company, but you send it off to the state of Colorado. This is a claim for compensation. I can't tell you how many times I've talked with injured workers to say, is there a claim for compensation? Because from my point of view, I'm trying to get people workers' compensation benefits. And the first thing I've got to do is get them an admitted workers' compensation claim. Well, I can't get an admitted claim until there is a claim. So, how long do you have to file a claim? And the answer is 2 years. 2 years. You have 2 years to file a claim with certain exceptions. For example, certain kinds of cancers, you have 3 years, or with what's kind of called excusable neglect. Like, for example, I don't know, if you were like Tom Hanks in Castaway, crashed on an airline, right? And you were stuck on an island and you were there for 3-4 years, and then you finally get rescued. Probably they're going to call that excusable neglect or excusable delay. But unless you're Tom Hanks, and by the way, never travel with Tom Hanks. All sorts of crap happens when you travel with Tom Hanks. You have 2 years. Now, that begs the question, 2 years from what? Is it 2 years from the date of injury? When is that 2-year time running? And this is where it gets kind of complicated, because it's not necessarily 2 years from the date of injury. It is 2 years from when you, as a reasonable worker, should have known 3 things about your work injury. Number one, you should have known what the nature of it was. Like, for example, if it's your shoulder and your shoulder's kind of sore, but you don't know, and then a doctor says, oh, look, you've got a rotator cuff tear. Then you know the nature of it. You know what's kind of wrong. If you've got some cough and the doctor says, God forbid, you've got some sort of lung carcinoma that's causing that cough, you know the nature of it. Number 2 is you recognize, or should recognize, the work-related connection between the condition, the injury, and work. And so, for example, again, God forbid, a shoulder, your shoulder's kind of sore, you're not too sure what. Doctor says, oh, you've got a rotator cuff tear. Do you do any lifting overhead? And you're like, well, yeah, that's my job. Oh, well, then this is probably due to your job. That's the moment now you know not just the nature, but you know the work-related connection to it, okay? And then the third thing is, You have to know the seriousness of the injury. So it's not enough just to have know what's going on, and it's not just enough to know a work-related condition. But for example, if I give myself a paper cut, you see I'm such a wimp, I couldn't even do that, But if I gave myself a paper cut, I'd know the nature, I'd know the work-relatedness. I ain't gonna file a claim, right? Because it's not serious, right? I put some paper on it and I'm done. But what if this gets infected and now they're talking about amputating my thumb? Once they start talking about losing time at work, losing jobs, surgery, hey, this is going to be permanent. Once you're given some sort of notice of that, at that point, you know the nature, work-related connection, and the seriousness. And then you have 2 years to make the claim. Now, we're lawyers. I don't have my clients wait to make a claim. The moment they become clients, if there isn't a claim, we make a claim, because we want to make sure that if the insurance company is going to deny liability, that we can fight that then and there. So, as always, never, never, never wait to report your injury. And number 2, you should make a claim as soon as possible, but with the help of an attorney who knows what they're doing, because we make sure that the claims are filed in such a way that you're not saying something or writing something that would cause the insurance company to deny it. For that reason, if you or anyone you know is injured on the job, please let them know that there is an attorney in Colorado who handles workers' compensation. We've been helping injured and disabled workers since 1995. We would love to help you, your loved ones, your neighbors, even people you kind of don't like. We'll even help them. And with that, thank you for spending part of your day with me.